Yes, a very good morning and welcome to our weekly program on legal matters. And I hope you had a very successful week. And today we are here talking about legal matters. As usual, we are giving you a chance even to be able to follow what we are saying this morning. Na leo basi mpenzi mtazamaji, tutakuwa tukizungumzia swala ambalo ni nyeti sana kuhusiana na jinsi ambavyo unaweza kufanya ukitaka kuweka kesi pale kotini. Na wakati mmoja labda umetaka kwenda pale kotini kupeleka kesi, lakini inakuwa ni tatizo kubwa, labda hujui utaanza wapi, hujui utamalizia wapi. Leo tumekuja kuzungumzia ni njia gani ambayo unaweza kutumia kuweza kuweka kesi pale kotini. Today we are talking about filing a case in court, as simple as that. Kwa hivyo kaa standby hapo, tutakuwa tukizungumza masuala kwa undani kabisa na wakili Bwana Ondieke Yuka aweze kutupatia kwa ufasaha zaidi kama wakili kuhusu kama uko hapo ungetaka kupeleka kesi pale mahakamani, unaweza ukatumia njia gani ili kesi yako iweze kushughulikiwa. Lakini pia we have a very simple question that we are asking you. What is the main challenge in case filing? What is the main challenge in case filing? Maybe you have ever filed a case in court. What challenge did you get when you are doing that? Or maybe your friend, your family, or your colleague had maybe filed a case, but there are various handles along the way. Today we want to hear from you. What are the main handles or challenges when filing a case in court? You can respond to us, or you can ask any question. Kama kuna swali yote ambayo uko nayo kwa wakili kuhusu kupeleka kesi kotini na mambo kama haya, uanzie wapi, ufanye nini, ni rahisi sana. Unatuandikia SMS kupitia nambari yetu ya SMS ya kawaida ambayo ni 23814 23814, our ordinary SMS number. Kama uko na mtambo wa WhatsApp, pia tuko na nambari yetu kwa WhatsApp ambayo ni 0721 105 and 105. Na lengo kula kipindi hiki ni kukuelimisha kuhusu mambo ya sheria, na ndio maana pia tunakupatia nafasi kama kuna swali, na labda hata si lazima ikuwe ni yale ambayo tunazungumzia. Kama kuna jambo ambalo ungetaka tuzungumzie katika kipindi hiki cha masuala ya kisheria, unaweza pia kutuandikia SMS ukituambia Bwana Kagi na Bwana Mangicho na wakili, tungetaka pia muangazie masuala haya ambayo nafungamana na sheria. Labda kuna jambo ambalo limekutatiza kwa muda mrefu na hujui utapata jawabu wapi. Ndio maana tuko na kipindi hichi ili kikusaidie kuweza kupata uelewa zaidi kuhusu mambo ya kisheria. Sawa. Kufanya hivyo ni rahisi sana. Chukua nambari yetu ya WhatsApp, tu text hapa 0721 105 105. Pia unaweza kutuandikia SMS ya kawaida tu 23814. Kabla kuweza kukaribisha wakili, niko na mwenzangu kama ilivyo desturi, Mangicho Mola, katika kipindi cha asubuhi ya leo, the Legal Tuesday. Mangicho, karibu sana katika Legal Tuesday.
Nashukuru sana Kagi, na furahi na vile kuridhia kuweza kuwa pamoja tena siku ya leo katika kipindi hiki cha the Legal Tuesday. Of course tunaamini ya kwamba msikilizaji wetu na mtazamaji wanaendelea kufurahia na vile wanaendelea kufaidika kuhusiana na masuala mbalimbali ya kisheria. Kama vile ambavyo watu tunasisitiza katika kipindi hiki Kagi, ni kwamba sheria ni kiungo muhimu sana katika maisha yetu kama Wakenya, ama hata vile katika maisha ya binadamu. Na kwa hivyo utakuta kwamba katika masuala kadha wa kadha ambayo tunakumbana nayo kila siku, ni lazima kwa njia moja ama nyingine tuweze kupatana na mkondo wa sheria. Na kwa hivyo natumai kwamba yale ambayo tunasaidiwa na wageni wetu, mawakili kama vile wakili wetu Ondieki, vile ambavyo wanatusaidia inakuwa ya baraka sana, na vile inakuwa ya manufaa kwa watazamaji wetu. Na siku ya leo kama vile ambavyo umesema, filing a case, I believe this is really going to be an eye opener and to be very impactful to many of our viewers. When you want to lodge a case maybe in the court, what is the process like? Where do you even begin? What do you need to have? What are some of the issues that you need maybe to put into consideration? What will determine whether your case maybe will move forward or will be required maybe to be halted because of one particular reason or another. Kwa hivyo natumai kwamba haya ni mambo ambayo tukizungumzia siku ya leo yataweza kuwafaidi wengi Kagi.
Yes, bila shaka Mangicho, na nimekumbuka tu kuhusu swala moja unaposhughulikia kuhusu legal terminology. kuna moja ambao ningetaka kupatia kibarua tu ushughulikie.
Gani hii?
Na ni kama ni methali inasema sheria ni msumeno, hukata
mbele na
nyuma. Na nimekaa tu nikakumbuka hiyo methali. So naomba utushughulikie, utuambie kwa nini wakasema sheria ni msumeno, hukata mbele na nyuma. Sawa.
Itakuwa nzuri kabisa.
Haya, karibu sana wakili Ondeki Ayuka. Karibu sana katika kipindi cha siku ya leo.
Welcome wakili. Good to have you again.
Yes, how has been your week?
Very well.
Yes.
Here and there. Blessings of rain, planting,
yes,
securing food at family level.
Wow.
Yes.
And awesome. One thing that really troubled my mind is how guys are doing to our farmers. Kwamba wanauza mbolea ambayo imechanganyikana kila aina ya kinyesi. Iwe ni ya punda, iwe ni ya ngamia, iwe ni ya mbuzi. Na sasa unalikuwa nashangaa kwani sheria nazo zilienda wapi? Kwa sababu tu kama watakana shughulikiwe kisheria.
Public utility, especially in supply of a huge consignment of fertilizer, which the government doesn't have, will get into a hitch. They wanted to avoid the cost of branding. That fertilizer should have been given to the government, it is branded in government of Kenya bags, and then transported. They could not have done that.
Yeah.
But now the winners of the tender supplied the fertilizer in their own name to a government institution, so they have an opportunity to put anything inside the bag.
Yeah.
But if the government had acquired the fertilizer in bulk and put it in government of Kenya bags, then we'll be able to say this cannot have happened. It could have been seen at the bagging stage.
Yeah, and
that was the loophole.
Yeah.
Yes.
And if this matter is not addressed legally,
yes,
then we are going to have a repeat on this in the next season. Right?
We'll have a big problem with it. Food production is a serious matter.
Yeah. Today, Wakil, we are talking about filing a case in court.
Yes.
And we are aware that there are many people who don't understand when you're filing a case in court, which is a process.
Yes.
Na pia kuna wale ambao labda wamefile kesi kotini, lakini wamekuwa na tatizo kubwa sana. I know we will be talking on this topic in depth today.
Yes.
But before we get there, maybe you may be able to explain to us, kuna watu ambao labda wanasikia tu kuna koti mbalimbali hapa nchini. Even before we go to how to file a case in court, maybe if it is okay with you, would you mind to be able to elaborate to us the different kind of the courts that we have in the nation, ili mtazamaji aweze kuelewa zaidi?
Yes, that's all right. In most of the situation in Kenya, most people know the courts that are near them.
Yeah.
The farmer in Molo knows that there's a chief magistrate's court at Molo. He knows that if he loses a case in Molo, he will come to the High Court in Nakuru. He knows that if he loses at the High Court in Nakuru, there is a process to the Court of Appeal that he may not understand, and there are matters that end up in the Supreme Court. So I think the general structure of courts that affect wananchi that they need to understand are, first of all, the court that affects them most is the magistrate's court. The judiciary is, that's the lowest rank of courts. The judiciary is attempting to have a magistrate's court in every county. In every sub-county, actually, not every county. So those ones are familiar. Then around the magistrates' courts, there are various tribunals. There's a tribunal dealing with business premises. There's a tribunal dealing with rent restriction. There is a cooperative tribunal dealing with cooperatives. And there's several other tribunals. There's a tax tribunal in KRA. All those are ranked as at the level of magistrates' courts, so that when you have a problem with them, you appeal to the High Court as a superior court. Then the next level is the High Court. The High Court now is structured because the population has increased. We are going into business. We used to have one single High Court that could handle succession, it could handle commercial matters, land disputes, it could handle all matters. In fact, it has original jurisdiction in both civil and criminal cases, which means it could handle any matter for any amount and to any amount in value.
Yeah.
So the High Court now is divided into, there's a commercial division, there's a human rights division, There is now a specialty court that we call the Environment and Land Court that was brought because once Kenyans started owning title deeds, they started disputing over matters of occupation and ownership of land. So there's a specialty court that is dealing with land and environment. About 80%, over 90% of the cases in that court are related to land disputes. People have not filed environment-related matters, except in big towns like Mombasa. There's one case, a big case in Mombasa. Then Nakuru, I think there is 1-2 cases. There's an environment case that has arisen in Nyamira, an interesting one, about the effects of gum trees on the water system. So we're watching that. So that specialty court exists. Now at the High Court level also there is the Employment and the Labor Relations Court. Yeah. This one deals with labor matters dealing with employment. The entry and exit from your workplace is dealt with in that court. Now, we have to have an understanding that in all these courts in the High Court, the disputes can be descended down to the Magistrates Court. There is also at the Magistrates level similar court that you can use depending on the value of your case. Then after the High Court, we have the Court of Appeal. Originally, most of the people will think of the Court of Appeal as being in Nairobi because of our history, that the Court of Appeal used to sit only in Nairobi and used to be a circuit court in Nakuru, in Nyeri, Kisumu, Mombasa. I think that's all those were the circuit stations. Now we have it in Nakuru, we have it in Nyeri, we have it in Mombasa. It is divided into 13 groups, so it is more widespread. That's the Court of Appeal.
And they have permanent structures?
Yes, they have permanent courts now in Nakuru. There is a Court of Appeal registry that has. We used to file a case in the registry in Nakuru, then it is taken to Nairobi for directions. Then the hearing will come to Nakuru for the convenience of the parties. But now we have a registry and the 3 judges that are posted to Nakuru.
Yes, before I bring Mangicho to pick up on the topic of the day, under the Magistrate Court, we have heard about the Chief Magistrate Court, we have heard about the Senior Magistrate Court, the Principal Magistrate. It's very confusing.
There's no confusion.
What is it?
It is ranking. It's like in a police station, you will have a corporal, you will have a private, you will have an inspector, a sergeant, and all those. In the Magistrate Court system, when we started, we used to have Magistrate Court grade 1 and 2 professional, which meant that there used to be magistrates that were lay magistrates at that time. But as we speak right now, the magistrate starts with a resident magistrate. You are employed as a resident magistrate. Your next promotion is a senior resident magistrate. The next is acting principal magistrate, then senior principal magistrate, then chief magistrate. Those are ranks, in the officers. The ranks mean something to them in that a chief magistrate may have jurisdiction to hear a matter of up to 20 million. An SRM, a senior resident magistrate, may have jurisdiction to hear a matter depending on the Gazette notice that are appointed to them up to 8 million or something like that. So it is a ranking. It shouldn't confuse anybody. Once you have a magistrate's court in your sub-county, it's a magistrate's court. What the difference is the rank of the officer is presiding. Yes.
Okay. Just to remind our audience that today we are talking about filing a case in court, jinsi ya kuweza kupeleka kesi mahakamani. Kama umekuwa na changamoto ya kuweza kupeleka kesi mahakamani, leo tunazungumzia swala hili kwa undani kabisa, na tuko na wakili Bwana Ondieki Ayuka ambaye anatusaidia kuweza kuangalia swala hili kwa kina zaidi. Kama uko pale nyumbani umekuwa na shida, ama jamii yako ama familia wamekuwa na changamoto ya kuweza kupeleka kesi kotini, tuko hapa kuweza kukusaidia. Na ndio maana leo tuko hapa tukikuambia, kama ungetaka kuuliza swali kuhusu kupeleka kesi kotini, situandikie SMS 0721 105 105 au 23814. Ya WhatsApp ni hiyo 0721 105 105, or any other issue or matter that you feel we can address at the Legal Tuesday. You can text us and tell us, hey guys, you can do this for us, and we are here and ready for you. Mangicho.
Absolutely, and I think that was a very good starting point, because it's very, very important, Kagi, for our viewer also to be in a position to understand the operations of the different courts that we have, and even understanding the different judges, just as Wakili has said, also in terms maybe of their rankings. And Wakili, I know there are quite a number of issues pertaining with this particular area, but if we can even just start, when you talk about lodging or getting maybe a matter or getting a case or filing a case in a court, and maybe we can start first of all, maybe who is qualified actually to file a case in a court?
Competence and compatibility, what Ringara used to use it. Now, if you thinking of filing a suit, you must be thinking about a right that has been infringed upon. Somebody has invaded or trespassed upon your land. Somebody has failed to pay your debt. Somebody has wronged you in a particular way. So the right to sue belongs to the person that has been wronged. Of course,
that is called the complainant.
That is the plaintiff in civil cases. The complainant is in criminal cases, where we deal with the police or DPP, and they file the complaint on your behalf. But in civil matters that we are discussing, the plaintiff, the person, the claimant, must have that grievance. He must have those facts. Maybe it's a contract for supply that has been breached, trespass on his land, taking away of his property or something like that. So once he has identified the wrong that has been committed to him, the person filing a case in Kenya has been so common that I suspect that most Kenyans know. What Kenyans have a problem with is perhaps procedures in court and that kind of a thing. So the person competent to sue is the person that has been wronged. That could be the answer to the question. Yes.
And this comes from if it's a matter of maybe you knowing or maybe you believing that in a particular way your right has been violated. Not necessarily because there are those maybe who might say that maybe they were told that their rights were violated.
Most of the cases come from facts that are very obvious and straightforward. They are not a matter that the party could speculate about. They come out of facts that are obvious or disputed. Perhaps a case where you could think of, you could be suspecting you have been wronged and you have not been wronged, would be like defamation. Libel and defamation. You may sue somebody for defamation, but realize that this person was exercising his rights on fair comment on a matter that is in the public domain. So that could be speculative. But when you think of somebody whose land has been invaded or taken away, or somebody who has been denied payment for goods that he has supplied to a particular person, the facts are relatively straightforward. That I'm entitled to 500,000 because I supplied you with 100 bags of beans at 5,000 shillings each. So the speculative part is very, very, very little in civil matters. Yes.
Wow, that is very interesting.
Yes. The dispute now could be is did you supply? Did I receive? Did I acknowledge? Are you entitled to the money? That is what the court will be trying. And there's a common saying we have that the court, between the parties that are in court, they know the truth. The only person who doesn't know the truth is the magistrate.
Okay.
Yes.
Very true.
These people know.
Before Kagi also comes in, when you are looking at when you're not considering to take now the case or maybe to file the case, is it necessarily important that you also know maybe who is the one that is accused of violating your right?
The parties to a suit are defined very well in the civil procedure. Once you are the claimant, you must know the person against whom you are suing. But in case you have a problem identifying the party, like it is a company or it is a group of people, there are parameters, legal parameters, that what each party did can introduce them to the case as a defendant or a claimant. So the determination, once you consult a lawyer, will be who did you supply your goods to? Who has trespassed into your land? Was he acting on his own behalf or on behalf of other people? Are there people that are behind the wrong that you need to include in the case? That is a very delicate determination that you could advise somebody to seek legal advice about, if in doubt. Yes.
And I was asking myself, Wakili, you have said that the person who institutes filing a case is someone who has been wronged.
Yes.
But at what time can I not file a case? Or at what time does police themselves file a case in court? The AG can file a case in court, and even the DPP can file a case in court, away from maybe I as a person.
All cases that you see in court are governed by rules of procedure. The rules of procedure at the very beginning provide for timelines for filing in civil cases. A contract expires within 6 years. A claim against the government has 1 year. You have to file it within 1 year. So the civil procedure itself will tell you whether your claim is still alive or it has expired. And there is also a procedure in reviving a claim. You can go to court and say that I supplied these goods in 2021. I traveled to England for studies for 5 years. I've now come in 2026. I didn't have an opportunity to vindicate my rights. Now, give me the opportunity to sue. The court will listen and say, we are extending time by, say, 1 month for you to file your suit. So it is not all lost that the 6 years are gone. Those rules of procedure will determine first the parties and the period of filing the suits. Yes.
So maybe to dig deeper, is there a time when a civilian does not file a case in court, but maybe the police themselves do that on their behalf?
In criminal cases, the owner of the case is actually the ODPP, the government, although the wrong is to the person. So the police can, after taking evidence, taking the statement, are the ones who ordinarily file criminal cases. When we talk about filing cases, generally we are talking about the civil cases.
Yes.
In police cases, we are talking about filing a charge against somebody. That's a government thing.
Okay, I'm sorry. I'm bit to that before we go further. We take a very short break, and when we are coming back, we'll be doing more on this on Legal Matters Tuesday. So stay tuned. Don't go too far. We'll be right back.
Okay.
MBCI Television, transforming lives.
Mohi Church, in conjunction with Naivasha Pastors Forum, invites all to a Healing My People conference, hosted by Reverend Githere and Pastor Susan, and co-hosted by Reverend John Gatia, Chairman of Naivasha Pastors Forum. The conference will start on 14th April to 21st April 2024, and the venue will be at Naivasha County Council Estate next to Hobra. The main guest speaker will be Reverend Jonathan Olesena, Bishop Jimmy Mwando, Apostle Othniel Mwambili, Bishop Moses Mbugwa, Dr. Lucy Nganga, Bishop Albert Naitera, Pastor T. Mwangi, among many others. The conference will start with morning glory, mid-morning sessions, lunch hour, and revival meetings. Saturdays will be special covered with workshops for teens, youth, men, and women. The theme verse is Jeremiah 8:21-22. Since my people are crushed, I am crushed. I moan and horror grips me. Is there no balm in Gilead? Is there no physician there? Why then is there no healing for the wound of my people? For more information, you can call 0722-813-178 or 0722-435-150. All are welcome in Jesus' name.
Kingdom Seekers Fellowship Nakuru invites you to a Power-Filled Ladies Conference 2024 from the 23rd to the 26th of April, hosted by Reverend Naomi Kemani and Apostle John Kemani William.
Know that you have power, my sister, my brother. Hata kama kuna hali zinanena kinyume, uko na nguvu, uko na mamlaka.
This is a divine opportunity to immerse yourself in sessions filled with wisdom, encouragements, and revelations. Guest speakers include Reverend Sami Mahoya,
self-neglect imeua watu wengi kuliko saitani.
Reverend Jacqueline Mwando,
Katika true foundation ya salvation there is transformation.
Reverend Miriam Gethenji,
Kitu chochote kizuri kinatokanga kwa Mungu.
Prophetess Winnie Andrew,
But a time comes you shout.
and Pastor Julia Karanja.
Don't give up.
The theme for this year's conference is Birthing God's Purpose. Drawn from Isaiah 66 verse 8. Music ministers will be Pastor Antho and Minister Magidon. The venue for this conference is the Harvest Cathedral, Nakuru. As we come together in fellowship, please remember to bring your bedsheets and personal effects. We'll provide the blanket. To reserve your spot, register at www.mbcimissions.com/ladies.
MBCI Television, transforming lives.
Right, karibu tena mpenzi mtazamaji katika kipindi chetu cha sheria kwa siku ya leo. Leo tunaongea kuhusu jinsi ambavyo unaweza ukapeleka kesi kotini, a way to file a case in court. Tuko na mwenzangu Magichomola na advocate Ondieki Ayuka katika kipindi cha siku ya leo. Wakili, kabla tuende katika break, we were looking at an issue whereby sometimes police themselves go and file a case in court. Is what we're trying to understand. When does that arise?
In criminal matters, the matters that are under investigation by the police, the product is usually called a charge sheet, which they file in court with the approval of the ODPP, Office of the Public Prosecutor. And once it is filed, the person is called upon to answer the charges. In most of those cases, either the person will be in custody or he is on police bond. So he has already been ordered to come to court. When we discuss about filing a case, we are actually referring to civil cases that are filed by individuals to pursue a right that they have. So there's a difference between the procedure in approaching the court, because the police simply file those matters and you are called upon to respond to the judge, take a plea of guilty or not guilty, and the procedure is slightly different. In civil cases, the individual makes the decision to file the case either in person or through an advocate.
Okay.
In most cases, most civil cases are filed through advocates, because in a court list of 40 cases, persons representing themselves are never more than 3 or 4. That is less than 10% of the cases that are done every day. People represent themselves. 90% are done by lawyers. Okay.
Yeah, and this is very important when it comes now to actually someone, especially now handling or involved in a civil litigation or killing. Yes. So when they want to have this particular matter, even when they are approaching the advocates, so that maybe this particular case can actually be taken forward.
Yes.
What are some of the issues? What are some of the elements that they need to present?
In civil cases, if you are doing it in consultation with a lawyer, the first thing will be documentation. What are the documents that you have? That is preparation of the evidence. What kind of evidence do you have? Once the documents have been put together, that's the profiling procedure. You now make a decision as to where does my case go. Will I file it in Kericho or Nakuru? That could be a question asked by somebody who is at Londiani, because he feels that transport and logistics to Molo, to Nakuru are better than going to Kericho. Okay. So you also have to think about where you are sitting and which court, which forum is the correct one for you. Like here in Nakuru, we have the Magistrate Court in Naivasha, we have the High Court in Naivasha, we have the Environment Land Court now in Naivasha, that is doing all matters that could arise in what was the old Gilgil constituency. So you choose the forum. Now, having chosen the forum and said that I'm not within Gilgil, I'm within Nakuru city, I can now file my case within Nakuru. You make a decision, you approach a lawyer with your evidence, and then the pleadings are drafted. Drafting pleadings is the most important part of the case, because the pleadings is the statement of claim. It is divided in paragraphs explaining who you are suing, what your cause of action is, why are you suing, what, without putting it in that paper.
But this time you've not necessarily informed.
You have not informed the other side.
Yeah, the other side.
Yes, okay. You now do what we call pleadings.
Pleadings.
You make a statement of claim, a concise statement of claim. Okay. These days you add your statement explaining the evidence.
And when you're talking about a document to kill, you're talking about things like title deeds.
A title deed, if it's a land matter, a current search, evidence of what has happened to the land in dispute, that kind of a thing. Then you have a list of documents that you will file together with the pleadings. That's part of the pleadings. You will have a list of witnesses and their statements, if they are available. Then those documents now filed, signed by you or signed by your lawyer, are filed in the court registry. After the court registry will assess the court fees to be paid. It is usually an amount that is determined by guidelines that are in court there. If you are suing for 100,000, the court fees will be about 6,000. I don't know the court fees in percentages, but it looks like it's a percentage of the...
Every suit incurs a court fees?
Yes, every suit incurs...
Depending on the weight of the suit?
Yes, except suits that you've been allowed by the court to sue as a pauper. You could come from like the slum areas. You may find that the people in a slum have been denied the right to water, but they cannot afford to file a constitutional petition against Nawasco. So they can approach the High Court and say, you see, here we are, 10,000 of us living in this sector here. We have been denied water, but we don't have money to file a suit. So the court can give them, can issue an order that they sue as paupers. That's the only occasion that you could think about. Now, after the court fees has been assessed and paid, the documents ordinarily are stamped. That is when you are given now time, 15 days. You serve the other party, who shall have 15 days to respond. After your defendant responds, you go for a mention to discuss whether everybody has filed everything that they need to file.
How is the defense? I'm interested in that particular, when you serve the defense, how are they supposed to respond?
They also file a statement of defense in similar structure as yours, agreeing with the statement of claim. And they're
giving a particular timeline.
Yes.
I've done that.
Yes, again, 15 days is the night time. So the defense will basically do either denial of the facts or an admission of the facts that are admitted. Yeah. So after it has been done, you have a case management conference. You come before the magistrate and say, I filed this case at this time. I filed all my statements. I have all my witness statements in place. The defense says the same. Then now the matter is ready for hearing. Then you go now for a formal hearing before the magistrate on the issues that you disagree. The case management conference might, in some cases and instances, resolve some of the issues. And then after they have been resolved, there will not be any issue when you are doing the main case. So that is generally the path that a civil litigant will follow up to the end until they get their judgment.
Before Kagi, you come up with your point. I'm just wondering, at that particular stage, Wakili, when the claimant is serving the defendant, on that particular notice of the court, is there anything that maybe the defendant can do to make the matter not to proceed?
Before he served?
After he served?
After he served, he may come to court and ask that the matter be dismissed because the facts are not available to the other side. The other side is suing on facts that are not correct. That is open to, you can raise an objection and they say that this matter cannot proceed to trial because this matter here is based on this and that falsehood. But it is difficult because what do courts do? They try facts. They try the differences in the facts as presented between the two parties.
And what if he agrees to what the claimant wants?
A judgment is entered against him and a decree issued for payment or for doing that which the claimant was seeking from the court. If it is vacating land, a decree will be issued to remove him from the land, for him to move voluntarily from the land within a period, or to be evicted. Yes.
Wow. Wakili, I'm seeking for some clarifications here.
Yes.
Let's talk about the level of pre-filing the case.
Yes.
Now, when you are pre-filing this case at this level,
yes,
can the case be dropped at this juncture?
At the filing stage?
Pre-filing stage.
Yes. You may present a case to a court that in its assessment, and by looking at the case, that case ought perhaps to be filed in a tribunal, or ought to go to another court with different jurisdiction, or is improper in a particular way, either procedurally or under the law. The court has two options, either to send the matter to the correct court, or to strike it out, that is, end the matter, but reserve your right until you go and file it in the proper forum. Yes.
Again, in terms of the evidence, during the same level, can the parties involved in the pre-filing of the case may be predetermined and advise you that, my friend, according to your presentations here, this case is not going anywhere. You better drop it. Can it happen?
That's the discussion that you must have with your lawyer, that these are the documents I have, this is the history of this dispute. I want this dispute to be taken to court. As to the chances of success and the nature of evidence, that is part of the pre-trial, pre-filing preparation stage. Yes. Once you make a decision that you are filing it in court, you have joined you have entered an institutional framework that will force you to go up to the end. But a case can be withdrawn at any time. Okay. You may realize that my case can't go far, and withdraw it. That is allowed. The claimant is the owner of the case in civil cases.
Okay.
Yes.
And during the case management with the judge,
yes,
maybe can something be determined at that point before taking the case to court? Maybe you agree, all the parties, the court, that is the judge, and all the parties involved, that no, we need to settle this matter. At this point, there's no need of going to court.
In fact, that is the purpose of the pre-trial conference. That conference seeks to determine whether there are any issues that should be taken to trial, whether there are any points of agreement between the parties that should be eliminated from the trial stage, whether the suit in its entirety can be concluded by agreement on some of the issues. You can draft issues and realize that the parties do not differ, or like in land matters, you may get to a pre-trial conference and realize that the dispute is actually a survey dispute. That Mr. Mola is living on Kagi's land because of misnumbering of the parcels. So at that stage you can determine that the only thing we need is a surveyor's report and this dispute ends. So the pre-trial conference is important. It can filter and conclude the entire case. Yes.
That's interesting. And I'm also interested with the issue of serving the respondents.
Yes.
What is the procedure of serving? Is it by dropping the letter to the respondents, or how?
Or calling them?
Or calling them. Again, how can court prove? For example, you can be served,
Yes.
And maybe if I'm served,
yes,
I am a little bit doing some fishy stuff. I want to
dodge the service.
Yeah. How can court prove that I was served?
Process in court is served by process servers that are appointed by the judiciary and are certified and licensed to serve process. They know exactly what to do. Once they get the summons from AK advocates, they will bring it to, they will look for the defendant and serve him in person. They will look for the defendant's residence or workplace and they serve him. So dodging service is not an easy matter. If you dodge it eventually, of course, the advocate will return the summons to court and they say that this person has evaded me for the past 6 months. I'm not able to serve them. So the court will tell them, okay, what do you want to do? Advertise in the news, in a newspaper, in the Daily Nation. And the court gives regulations, and you are served through an advertisement.
Wow.
Yes, in the Daily Nation.
Can there be issued a warrant of arrest?
Not at that stage. Warrants of arrest are execution matters. At the time you get a warrant of arrest against an individual in a civil matter, it means there is a judgment or there is an order that that fellow has failed to obey. Warrants of arrest in civil cases are execution stage procedures. They are not trial stage or preliminary stages. Yes. You cannot issue a warrant of arrest because somebody has dodged service. You look for ways of serving them.
Wow, you look for ways of serving them.
Yeah.
So, and would that pose some challenge, Wakili, in terms of maybe even the time frame under which maybe a civil litigation can actually take?
We have time frames even in trial that a matter once it starts should be heard within 42 days. Those are internal regulations by the judiciary for efficient delivery of their service. But once you file a suit, the duty to serve, you have 1 year, 1 full year to serve the summons. Summons to enter appearance expire within 1 year. So because it is a claim against another citizen, we cannot say that we are losing time. we must make sure that the proper service has been rendered. That person has gotten the summons, he has gotten the statement of claim, your witness statements and the list of documents, and he is preparing to come and defend themselves. Yes.
And talking about witnesses, and maybe you're also being represented by an advocate in this particular case, are there circumstances under which one, maybe in this particular case or in this particular suit, is supposed to testify by themselves?
The primary evidence in a civil case is given by the claimant, the plaintiff. The plaintiff is usually the first person to testify. In very rare cases do you find a witness testifying before the owner of the case testifies. But it happens in some circumstances where perhaps securing the evidence of that witness is going to be difficult. He's traveling out of the country, you need him, or he's a professional whose evidence you need on record, and he will not be available for a long time. Otherwise, the procedure is the owner of the case testifies before his witnesses.
Okay. And even as it continues, are there also scenarios under which maybe now the legal parties, or maybe the legal support for the other side, for the defendant, can cross-examine the claimant?
Trial procedures are simple. It's the statement from the claimant or the witness is cross-examined in court by the defense counsel. Is re-examined to clear up any issues that have arisen in cross-examination. It is the normal trial as you know it. There has to be a testing of the evidence by cross-examination by the other side.
What needs to happen here? Because I think sometimes when it comes to this cross-examination, some of the parties maybe sometimes they fall, or maybe they are actually overcome by the challenge maybe of the legal expertise.
Not really. Courts are street front affairs worldwide, except that in Kenya, because of terrorism and other concerns, we now have courts that have gates and locked doors. Courts are supposed to be open forums. They are very friendly to the people who come to testify and use them. Anybody, we have had old people, young people, people with challenges testify in court. The reassuring presence of a magistrate sitting in between the parties or a judge usually calms down most people, and they give cogent evidence. You cannot say that it's a big challenge. But of course, somebody may feel intimidated by counsel and the counsel's manner of approaching the issues in dispute. That's where the magistrate comes in now to moderate and say, no, let this lady, this old man, let this young man explain himself. We want to understand the evidence. We want the evidence on record. The most important thing is that the evidence be placed on record.
Okay. You talked about when you are filing a case, it's mostly done through an advocate.
Yes.
My main concern is it maybe unlawful, or is it a culture that you can only file a case or maybe present yourself in a case through an advocate?
Yes.
Number two, I have seen even advocates themselves, when they have a case in court, they don't present themselves, and they are advocates. They call upon their fellow learned friends.
Yes, to present
Why
them.
so?
An advocate who has a problem that he wants to take to court, if he represents himself, has a fool for a client. So it is dangerous to represent yourself. Your passion for whatever legal right you think has been infringed will be such that you will not be able to be balanced in dealing with the matter and taking perspective from the other side that has been sued. So it is usually better that you submit your facts to a colleague, an advocate, who will represent you and be balanced and be able to tell you, you were wrong here, they were right here. That is the rationale. What was the first part of your question? No, there is no law that your matters must be taken to court by an advocate. Okiyo Mutata, my friend, has shown Kenyans that you can draft petitions and take them to the High Court and even to the Supreme Court, argue them, and they get results. The only thing that, the only caution you have to have is that because of the technical nature of civil procedure rules, from initiation of case up to the end, up to execution, it's advisable to deal with, to have the matter dealt with by advocates. And it's also good for business.
Okay.
Yes.
Is there a situation where,
Yes.
sorry, maybe you can continue?
No, just proceed.
Is there a situation whereby you can decide your case can be filed privately, and also you maybe request the court the same matter be executed privately by the judge?
That is in camera.
Yeah.
No, unless you're dealing with matters in personal law, like you're dealing with a divorce proceeding, matters involving minors, children of tender years, that may be affected by appearing in proceedings, most matters will be heard in open court. But a request for hearing in camera, as we commonly call it, is allowed at the discretion of the judge, considering the facts. We have had people go through divorce proceedings using acronyms, AK versus YS. And the matter goes. And
so most of the divorce cases are done in camera?
If a request is made, I believe they will not be done in the open, especially if the couple have children of tender years.
Okay.
Yes.
Those are some of the factors that the court
the court will consider and say, let's do this thing in this manner here. Let's exclude the public. And of course, the matters involving minors under the Sexual Offences Act in the criminal area are done mostly in the absence of the public.
And does it mean to ensure that they maintain the same confidentiality of the case, because maybe one party would go ahead and maybe give the information to the media?
It is not really a media avoidance thing. It is the decorum in doing the thing, which is common to both parties. That danger is there. Of course, there's nothing that you can do in an open forum like a court that will never be known. It will get known who and what happened. So that is not a consideration. The consideration is actually the special issues in that particular case. The choice of the parties, the interests of the minors, perhaps in the union, and that kind of a thing.
Yeah. The issue of the martial court.
Yes.
For example, we have a disagreement with the military.
Yes.
Do we file our case in ordinary courts, or I take them to the martial?
The martial court is a specialty court that is empaneled by the commanders in the military under the Armed Forces Act. It is, I think, Cap 199 of the laws of Kenya. It does not deal with civilian issues. If a person in the military causes you a grievance that you want to take to court, you take it to the common court. And if it involves his service in the military, what they do is that they discharge him and they tell him to do his things. That one deals with the issues of discipline and the conduct of the army, and also offenses, civil offenses. We call them civil offenses, like procurement offenses, stealing and that kind of a thing, of things within the military. That's when the martial court comes in. It does not do trials between citizens and the military. Yes.
Okay.
Yeah. And what about in terms of judgment, Wakili, for civil cases? What are some of the common judgments that would be delivered? Sentencing, for example, a common phenomenon, or it is mostly maybe a matter of compensation for the aggrieved?
You're mixing the jurisdiction. In criminal jurisdiction, the judgment will be the custodial sentence and non-custodial sentence coupled with compensation to the person who has been wronged. That is the criminal realm. In civil cases, you have made specific prayers. You have said that discharge so and so from my land. Evict so and so from my land, or order so and so to give me 500,000 shillings, being the value of goods that I supplied to him. So the court will not give you anything other than the prayers that you have made there. In fact, the law is that you are bound by your pleadings and your prayers. What you ask for there, if you succeed, is what you get. Of course, the court has a discretion to temper and to give you a remedy in particular terms. But in general terms, what you ask for in civil cases, if successful, is what you get.
Is what you get.
Yes.
And maybe to just look back,
yes.
What are the common mistakes that people do, especially for the common mwananchi, when they are filing a case? What are the most common mistakes they do that cost their cases?
A poor preparation before filing, like gathering of the documents and evidence. Skipping vital documents like filing a copy of a title deed without a search certificate. That may prove fatal for the case. I've even seen a case where somebody filed it with a search originating from the registry in 1992. Yes, it doesn't have a search for 2024. He has filed a case in 2024 with a search that was done by either his grandfather or somebody in 1992. So most mistakes occur in pre-filing area. There may be mistakes in choosing the forum. Like because you're in Londiani, you decide I don't want to go to Kericho, I want to go to Molo. So the court may have to correct you and return you to the Kericho Law Court. Then other than choosing of the forum and the preparatory mistakes, perhaps drafting errors, but those ones are not fatal. The courts over the years have come up with a regulation that we don't have to be overly technical. If there is an error that can be cured, it can be cured, and so long as we understand the claim, we'll proceed with the claim, so long as most of its body is correct. Yes.
At what juncture, after you have filed the case, it is now active in court, that you feel you need to drop the advocate that is serving you in court?
Yes. Anytime you can change your advocate. I've seen advocates change it as the matter proceeded in court. But it stands up and says, I want to look for another advocate. I want to be presented by somebody else. An advocate also has an option to withdraw from any matter at any time. So it is a contract, a mutual agreement contract. If you feel that you're not serving each other's interests, any party can exit at any time. Yes.
And there is also a possibility one can also even get or access the services maybe of several advocates?
Yes, it depends on what you want to do. You have seen cases where people, although it is mostly in the criminal realm, people get represented by 100 lawyers. But usually when that happens, the purpose is to stall the proceedings for good. Because when you get to court at 9 o'clock,
yes,
by 10:30 the court has not completed taking down the names of the lawyers representing the accused person.
They push it again to tomorrow to continue introducing themselves.
Yes. Usually it is to stall the process. I remember a case where 3 advocates were involved. One assaulted the other. They are famous people. Then when they came to court, one arrived with over 300 lawyers. And the magistrate had to start recording. The case died, but then those numbers have that kind of a purpose.
There are some situations whereby maybe after the proceedings is active in court, the claimant maybe goes to court, the lawyer or the advocate is not available, the case does not proceed.
Yes.
What circumstances affects your case if the advocate does not avail himself in court?
Case management challenges are always there. The advocate may not be able to come into court, or the advocate may be engaged in another court at the time your matter is called.
Right.
It's a matter of personal organization, organizing the diary of the advocate and ensuring that you are in court at the time you are required. But those hitches occur. Litigation is a very human affair. You may be driving to Naivasha for a case and you get a problem on the way and the matter is called before you get there. So the courts usually weigh what the thing is and manages the process within the law. It gives the person an adjournment, an opportunity to be heard on another date, that kind of a thing. All challenges that arise within case management are in the province of the judicial officer. Can decide, let me give you a date in June, come with your witnesses, your advocate is late.
And suppose the lawyer is having a serial absenteeism in court?
Then now the magistrate will have to insist on proceeding, which will force the client to look for different representation. Yeah, you can say, we have adjourned this matter 3 times. Because of the absence of your lawyer, we want to hear this matter in June, but that time we will proceed.
And I think
it usually works.
Okay, it usually works. Thank you, Akili. And I think in this particular case, because I think the place of an advocate, and Kagi maybe you'll agree with me, it seems to be very, very pertinent, Wakili, very paramount. So how does one determine which advocate to stand for them in such a proceeding?
Advocacy is, to use the terms, a very, very open market. So many law firms, so many advocates that are doing the same thing. It's the choice of the client on who he wants to represent him in court and in what kind of a matter. Advocates are chosen most of the time by what you may call reputation. Do you know him? Or what does he do mostly? And most of that reputation is accumulated experience in a particular area. Once you appear in land court every day, it is likely that somebody looking for a lawyer in a land matter will come to your office. If you appear in the Chief Magistrate's Court in criminal trial every morning, it is likely that somebody looking for a lawyer to represent them in a criminal case will come to your office. But the answer is it's an open market. You can use, all advocates are trained to do the same things. It's a matter of preference. He may tell you, I do not take murder trials. I do not do that kind of a case. It can happen.
What about, could one of the considerations be how this particular advocate, how many cases they have won?
We usually say that advocates have never won or lost 10 cases. It is you people bring bad cases that you lose. That's what we call a matter of reputation. Yes. Marketing legal services is a very, very delicate thing. Yes. It depends on what people know, what do they feel, what do they think about the dispute they have, and how they want to progress it.
Okay.
Yes.
Okay, just to remind you, dear viewer, that you are watching the Legal Thursday, and today, Tuesday, not Thursday, and today we are talking about the filing a case in court. And if you have a question to an advocate here in studio, Mr. Ondieki Ayuka, you're free to be able to text via our WhatsApp number 0721 105 105. 0721 105 105 is our SMS number. Or maybe if there is a matter that you feel this program can be able to address in terms of enlightening public on legal matters, we also give you a chance to be able to text us and tell us, hey guys, you can be able to handle this for us. We are free here to be able to serve you on 0721 105 and 105, right? And Wakili, the matter of how do I, the cost, the cost of the case. For example, the judge determines a case, and then you are told to be able to cater for the costs.
Cost of the case.
Yes. How does it come in?
At the tail end, at the very end of your statement of claim, you have to ask for the costs of the case. And if you are the successful litigant, there is what do you call an administration order. There is a law on how much is charged for what kind of value and at what level of court. That's a regulated thing. You can't change it. If the value of the property is 50 million, there is regulated fees for that. Then plus, of course, your disbursements by filing fees, disbursement and that kind of a thing. It is regulated by law.
So who is supposed to pay this? The defendant?
The person who loses the case, yes.
Even if you are the claimant who had lodged the case?
Yes, yes. They say costs follow the event. So the event is the loss. So you have to you pay those costs.
But not all cases whereby you can be able to bear the cost.
Yes, there are cases you find that there's a brother suing a sister over land. Most courts now have developed a system where they say that this suit was between Kamau and his sister Wangeshi. Being family members, we have ordered each party to bear their own costs. So nobody pays the other costs, whatever the result.
Yeah, Mangicho, this is very common during the election petitions. It's very, very common. Yeah.
But I think the most important cases, perhaps, that people need to understand how to deal with are succession matters, because quite a number of people out there have not filed succession causes. Yet they're the easiest thing to file. Get a letter from the chief. Let him identify all the children of the deceased and the beneficiaries, including the ones who have died. And if they have widows, who those widows are, then you come to court. The forms, it is a form system. It's simplified because the particular forms you fill, 82, 80, 57, 5, 12, and 11. So, to summon kujaza form, and you already have a case. Yes. Succession matters are very simple. Even if you came to my office and I took a computer, you key in the names, the matter is ready for filing.
All right.
Yes.
Sawa. Mangicho, at this juncture, we are waiting eagerly to hear more of the legal terminology.
Of course, as you always know, our dear viewer, we always bring you that short segment where we familiarize ourselves, we educate ourselves with a number of terminologies, some of which you may find yourself meeting them or encountering them, maybe when you visit a court. And I know this is quite common, especially even for law students and even media law students. It's called mens rea. Mens rea. This is a term that literally means guilty mind in Latin. So the term actually is in Latin, cagi mens rea. It's used to describe the criminal intent of an individual when committing a crime, otherwise known as criminal responsibility. So when you talk about mens rea, it is a term that literally means a guilty mind in Latin. That is, mens rea is used to describe the criminal intent of an individual when committing a crime, or otherwise known as the criminal responsibility. That is what we mean when we talk about mens rea. And of course, Wakili will always break it down for us.
In very ancient times, around the 16th century, people used to end a plea of guilty, a plea of not guilty, or what we call a demara. That is, the facts are true, but they don't disclose an offense. So in trying to sift through the system and differentiate between those where the facts could be true, but they don't disclose the offense, the doctrine of mens rea was created, so that now, apart from the facts, we also add the element of the intent to commit the crime. That's how it arose. So because the law was developing in England, where we borrowed it from, they borrowed from the Latins. That the Latins used to say that this under this is the element of the offense. But to make it complete, we have to have this intent. So that's the way mens rea came into the law in England around the time of Bacon and about 1600. 1559, 1600.
But why are majority of these terms are in Latin?
Because what was codified as law in England, which came here, was codified from the Latin statutes. The first settlement across the Mediterranean, around the Roman, the Latin area, the first settlement that was there, that was actually an African settlement, the Moors of northern Africa, a mixture of people, Persians, who became Iranians and Pakistanis. That first settlement, before it dispersed, did many things. They even created mathematics, instruments of measurement, and all that kind of a thing. Wow. So it is just that like a connotation, that civilization of that time created many things.
And there seemed to be a constituency of a very learned group.
Yes.
By the look of things.
Yes. The people who lived in that place, wherever they have gone, they have been what we call the salt of their communities. Yes. Just like religion originated from the Middle East, these learning and other things also had a source. The North Africa and the Southern Europe part.
Okay. Sawa. I think now we can be able to move on before we come close to the program today. Mangicho, again, we need to see what you have for the legal profile.
Absolutely. On to our legal profile for today. This is where we focus on quite a number of legal personalities. And today we are looking at this gentleman by the name Kagi, Justice Daniel Musinga. Yes. Justice Daniel Musinga. We have a few highlights about Justice Daniel Musinga. 1987, he graduated with a Bachelor of Law degree, that is LLB, from the University of Nairobi. Come 1988, Justice Daniel Musinga was admitted to the role of advocate upon completion of diploma course in the Kenya School of Law. Then in 1988 to 1991, he served as an assistant in the firm of Gikandi and Company Advocates in Mombasa. Then 1991, again, he founded his firm, that is Musinga and Company Advocates. Come 2003, he was appointed judge of the High Court of Kenya. That happened back in the year 2003. He's also served and chaired the Mombasa Law Society of Kenya, as well as the Kenya Christian Lawyers Fellowship. Very instrumental there. He was instrumental in the Kenya Christian Lawyers Fellowship. He also served as a High Court judge in Nakuru, that is until 2008, before he was transferred to Kisii. And while in Kisii, he was actually nominated by LSK for the award of Outstanding Judge in the Administration of Justice for year 2010. So he was nominated for this particular award. Then in 2011, Justice Daniel Musinga was honored by the International Commission of Jurists, that is ICJ Kenya chapter, as Jurist of the Year. That came way back in 2011 when he was honored by the International Commission of Jurists, ICJ Kenya chapter, as Jurist of the Year. And in December 2012, he was appointed judge of the Court of Appeal, and in 2021, he was elected president of the Court of Appeal in Kenya. That is Justice Daniel Musinga.
Yes, and he is very popular in our legal corridor. And one thing I can see is that he has achieved a lot. Nomination by the LSK, and also got an award, international award. And you can see he was, I don't know whether he's still there, but the Court of Appeal president. It's a very great achievement in his career.
I don't know whether he could be still the Court of Appeal. I'm not very clear on that. But Musinga has been he has a lot of influence over his career. He's a member, and I know he even comes to Nakuru for the annual carols before Christmas. Yes.
Oh, that is very interesting.
Yeah.
And because we've seen some of his profile there, Wakili, when he was in Nakuru, you said he was the High Court judge.
Yes, he was the High Court judge.
Well.
Yeah.
He is one of those people that you could expect at some point to go to the